Thank you all for being back. I'm sorry we're a minute late. Yes.
My Lord, I was going to take the court if I may. Oh, sorry. Can I hand up the full passage of the Act, finally?
Thank you.
I think also we're going to try over lunch to get the full copy of the regulations, just because in attempting economy, I think we've left things out which we can...
Yes, but I think my lady and my lord are right that we need to see the full...
well, particularly if
Thank you.
particularly if I'm making a submission, one could construe the instruments as a whole. I think my Lord
Yes, well,
Snowden put to me very fairly.
So these go between page 4 and 5. Well, in fact, it's the whole. It's the whole. It is the whole Act. So we can
The
just
whole
do.
thing, yeah.
Yeah. Do you now we've got our hands on it? Do you want to make any point about what we can now see that we couldn't see before?
Well, my Lord, it's really only the points which I think I sort of made parenthetically in section 7, where it goes over the page. It just uses the word directing the disposition or interment of the ashes.
Yes.
And that's a slightly different and I think maybe more helpful word than disposal.
Mm. Even though disposal is actually used in the regulations.
No, exactly, milady. There are some nuances.
Mm.
It does seem to draw a distinction between the burning of human remains and the disposition of ashes, though.
Indeed.
Yeah.
I mean, there is an overarching point which I do want to make clear to the court. We say, on a functional analysis, there is such a close connection between having ashes and having to do something with them and the cremation that they would naturally fall within the language of incidental or ancillary to anyway, regardless of the fact that, in addition, specific provision is made within the Act and regulations relating to their disposition or disposal. So, for example, the functional test which Miller and Friends urge upon the court, and which I think to some extent the judge attempted to do based on his idea of the purpose, is to see where there's a close functional relationship. We say the learned judge drew that far too narrowly, and I'll show you the passages in which he did that. But functionally, the existence of the ashes as the product of the burning of human remains is so closely connected to the burning of human remains as to fall naturally within what you have to do with those, falls very naturally within the words ancillary or incidental.
And they clearly are connected because they're the product. But the Act, as we saw from the long title and elsewhere, is concerned with the activity, the burning.
Exactly.
Not with the disposition.
Yes. The Act is concerned with the burning. We respectfully say, when you construe the words in section 2,
Appliances for the purpose of.
Exactly, and shall include everything incidental or ancillary.
To the burning.
Exactly, there too. That necessarily, we say, either on the natural construction of those words in themselves, or because the Act and regulations make specific provision in relation to disposition and or disposal. We say there are two routes to the same thing. So, for example, the functional link with car parking is not of the same quality as the functional link with where you dispose of the ashes. When you're talking about, is it incidental or ancillary to the burning of human remains?
So you're accepting that what it has to be incidental or ancillary thereto is burning human remains.
Indeed.
Yeah.
I mean,
not ancillary to the building, for example.
Well, on the face of it, it may mean either, but I'm just making the point that it is
Well, I
even
want to know which side of the line you're jumping, because
Well-
it could make a difference.
yes,
Is it everything incidental or ancillary to that building, or is it everything incidental or ancillary to,
I think
to
it
the
must
burning
be-
of human remains?
I think it must be to the purpose of the burning of human remains.
Yeah.
So it's not
That's what
the
I'm-
burning of human remains,
Yeah.
it's the purpose of burning
Ancillary
of human
to-
remains, to which on a proper construction it's
Yeah,
ancillary.
because you don't generally talk about something being incidental to a
To a
building.
building.
No,
You do talk about something being ancillary to a building,
exactly,
not incidental.
No.
exactly.
Yeah.
So I think it must be incidental or ancillary to the purpose of burning human remains.
Yes.
But you still say that includes what you do with the product.
Exactly. It's about as close as you can get.
But it doesn't include what if the member of the public whose relative has died takes the remains and then scatters them on Glastonbury Tor or whatever.
No, it doesn't.
That's not included, obviously, in
No,
the definition.
absolutely
So
not.
what's the difference?
The difference is that once they're taken away from this is regulating what crematoria do.
Yeah,
It's not regulating what members of the public do
right.
with ashes.
So
that are
if the
taken away.
crematoria, in the discharge of their responsibility under the regulations,
Exactly.
inter them
Yes.
in a piece of ground, then that's ancillary to the crematorium's activity, which is
Exactly.
the purpose,
Yeah.
for the purpose of.
Or stores them
remains.
temporarily pending their collection, which is I think accepted. So you've got this odd thing of temporary storage accepted, interring permanently accepted, but storing them for a very long time in the same place you might otherwise have interred them not accepted.
Right.
Which we say is
And-
strictly says.
And something I was wanting just to, when you took us to the plans, I wasn't clear where it is said that the long-term external storage facility might be.
It's the memorial garden, which is the top right, which is
All of it?
it appears to be the whole of the memorial garden, unless
And what I'd understood you to say, and
Yes.
it may well be that I was wrong, was it was the whole of, potentially the whole of that,
yes,
and that what would happen was above ground pods,
exactly,
whatever
yes,
other word might be used, of ashes. So instead of, one's familiar with going to perhaps a churchyard where there'll be flat stones marking where
Exactly.
ashes are interred,
yes,
these would be above ground.
yes,
That is your point about 2 centimetres
exactly.
above or 1 centimetre
Precisely.
below.
yeah.
Anywhere in that memorial garden.
And I'll just parenthetically, when you visit a churchyard, sometimes you find rather a grand grave, which is where the one's actually above the ground.
Yes.
But it doesn't mean it's not been buried.
No, that's the memorial stone may be above the ground.
Exactly.
But the remains will be.
The remains
below
will normally
ground.
be interred below ground.
Yes.
But so the memorial area, we just go back to the page 28. In the supplemental bundle. Actually, I think the best one to look at, sorry, I think the best one might be to look at the one at the beginning on page 8, because it's got the arcs.
Well, I think it was the one with the multicoloured, and you were taking us to the green at the top.
Yeah.
It was. So there's both. The coloured one is on
Page 32.
page 32.
Yes.
And if the court keeps a finger in that one and turns back to page 8, just to flick back to page 8, to see the memorial gardens are in the top up near the wetland,
Yeah.
Yeah.
and that's sort of triple, or 1, 2, 3, triple, at least part of it is triple prohibited.
Yes.
The top right hand corner, because it falls within the arc and the top straight line and the side straight line along the
Yeah.
main road.
The arc is from the building in the bottom right-hand corner.
Dwelling in the bottom right hand corner.
Is that a dwelling? Or is it a, what is it?
There is a There's a dwelling in the bottom right. I think it's the Budgeons. Are the Budgeons in the bottom right corner? Yeah. A family called the Budgeons live in the bottom right-hand corner of them.
Okay, so it is a dwelling house.
There's a dwelling house,
Yeah. And then, just while we're clarifying, you took us to what was said about a different facility run in Scotland, and
Yes.
showed us the photograph of what
Yes.
was the common cairn.
Yes.
There. And I think I'm not clear whether that's part of the proposal here.
I think it may
or
be.
not.
I think it's they can have individual or common.
Yes, and I don't think we know where the common one would be, whether it's
We
within
don't.
the central triangle or somewhere else.
Oh no, it's not in the central triangle. I mean that's the point, is that they say, because if we look at their case is that the memorial gardens, which normally would have to be within the non-prohibited area, they're obviously in a site like this. I mean, the Farley site is far bigger, so there's lots of room and so forth. But in a site like this, there isn't room to have the interment of any ashes there at all.
Yeah.
So they finessed it, as we saw in the emails, by saying, well, okay, the memorial gardens actually count as ornamental because they're 2 centimetres above the ground.
Yeah.
So they can be, on their portion of the Act, the memorial garden could be right next door to the Budgeon's house. Or within a few yards, if they wanted to.
So I think that's clear now. Yeah. Thank you.
So, my lords, my lady, can I just look quickly, if I may, at the learned judge's judgment? The relevant parts in the core bundle at tab 7. And it's the relevant parts type is really between pages 110 and 113, where the learned judge reaches his conclusions. And could I just start with the conclusions in paragraph 110 on page 113? That's tab 7, page 113.
Excuse me.
And the conclusions on ground 1, because for reasons I've given, I conclude that on the evidence for the inspector, definition of crematorium in section 2 of the 1902 Act did not extend to the access roads, car parking areas, or the memorial gardens. The inspector was correct in law in concluding, as I have found he did, that the location of those elements of the proposed development would not contravene section 5 of the 1902 Act, which therefore presented no impediment to the delivery of the proposed development and its ability to meet the pressing need for new cremation facilities. And then he reaches the same conclusion on the location of the crematorium building itself, on the doors and windows. At the short point, we respectfully say the lady's point is quite right, it's easily got round, but the short point is it wasn't actually got round. It doesn't take the appeal anywhere in particular, but
from a planning perspective, it's de minimis.
Exactly. And then if we look at the bottom 3.5 lines of that paragraph, there was no evidence that the opening of doors and windows would in any way materially affect the process of burning human remains at this crematorium, or the operation of the appliances for that purpose to be located within the crematorium building. We respectfully say that, although on a point which the lady rightly says is de minimis, it does betray the approach that the judge appears to be taking to the construction of the provisions, which we respectfully say, as I think I hopefully explained already, it wasn't correct. If we begin at page 110, just to show how...
Although the sentence as it stands is correct, isn't it? I appreciate you say it betrays a misinterpretation of the Act, but as far as the sentence goes...
True.
It's unobjective.
The sentence is correct. It's just what it tells you about the reasoning I think was being adopted about Section 5.
Yeah, because as I say, I can't for the life of me find windows at the moment that actually open anywhere, other than perhaps from an office or something.
Yes, I think there are some on the south side marked as windows, and we can't tell. They're not on the drawings as where they opened. Only the apertures, the doors are shown.
Yes, and the only doors that infringe are the exit doors for the congregation. I think.
So, I mean, lady's quite right. It's de minimis.
Yeah.
And I'm, so I'm not pressing the point, but I do say it's quite revealing.
It's very difficult to see how public sensibilities are going to be offended by whether a door moves outwards or inwards, frankly.
Agreed. But if we go back to paragraph 93, the judge rightly identified it as a point of statutory construction. Just pausing there, there are obviously two grounds in relation to the Cremation Act. The first is the proper construction of the Act. The second is the reasoning of the inspector. And I readily accept the reasoning of the inspector doesn't take it any further, because even if inadequate, if what he did was right as a matter of law, it was right, and what he did was wrong as a matter of law, was wrong. And it's not saved by the fact that that issue per se was not identified as a main issue, because what was identified as a main issue was whether very special circumstances which were necessary, and this was absolutely critical to that, as the learned judge rightly accepts. So I think ground two, all we would respectfully say is it is actually impossible to see on the face of the reasons exactly why he said what he said, and even on the learned judge's test for the giving of reasons, which should not leave any room for doubt that he's made an error of law or not. It fails that test, but I mean nothing particular turns on it. So I'm not going to spend time in relation to that. It was essentially one had to engage in sort of guesswork about why he decided what he did on that point. Paragraph 93, he cites tidal lagoon. And we've got that in the authorities bundle. And if I could just invite the court to look briefly at that in tab 10 of the authorities bundle. If we go to page 175 in the tab 10, which is internal page 501 of the report, the paragraph to which the learned judge referred is paragraph 30, which should be sidebarred with a red line.
Yes. And
it's the passage beginning on the second line. The court's essential function is to ascertain the meaning of the statutory words having regard to the purpose of the provisions in question, etc., give effect to the best. So we agree about the principle of correctly identifying the purpose and construing accordingly, and we disagree about the purpose that he identified. That is also a passage relied on by my learned friends, but if you look at paragraph 31, that's also helpful. He goes on to say, there is not a different or less rigorous approach to the interpretation of planning statutes and statutory instruments. It is not appropriate in this case, which concerns the construction of legislation, to rely on authorities that caution against excessive legalism in the interpretation of planning policies, planning officers' reports, or inspectors' appeal decisions. We note, however, what Lord Hodge said in Trump International Golf Club Scotland and the Scottish Ministers, paragraph 34, when the court's concerned with the interpretation of words in a condition in a public document such as section 36 consent, which was a development consent order, it asks itself what a reasonable reader would understand the words to mean when reading the condition in the context of the other conditions and of the consent as a whole, and that this is an objective exercise in which the court will have regard to the natural ordinary meaning of the relevant words, the overall purpose of the consent, any other conditions which cast light on the purpose of the relevant words, and common sense. And the only points I wish to draw out of that paragraph is firstly the no case for any lack of rigour because it's planning, which is an unsurprising proposition in relation to statutory interpretation. Paragraph 31. There's no warrant for a caution against excessive legalism in interpreting a statute. Statute is a statute is a statute.
Well, that's hardly surprising because normally in the planning context it wouldn't matter whether the proposed development infringed a statute or not.
Exactly. Yes. Lady, it's only where there is that functional qualification which makes it genuinely issue. The problem is your ladyship knows a lot more about this than I do. So I'm respectfully agreeing.
Well, I'm sure one of your colleagues will correct me if I'm wrong about that. But the general rule is that it doesn't usually matter because you can get planning permission for a development and it then turns out that it infringes some highway provision or something that nobody's actually seen. And that's exactly what happened in the Holocaust Memorial case.
Exactly.
Because nobody actually appreciated that it infringed this Victorian statute until somebody went off and did some research about it.
Exactly. So normally, and there are, and indeed in the planning context, the fact there might be other legal barriers to you doing it doesn't matter either.
No.
Normally. But where
say here it's integral to
I think that's common ground and the judge found it.
Yes.
So I think we're safe.
Yeah.
But that's a little bit of a very narrow sliver of territory that's not in dispute. Yeah. Rather like the proposed development. So the short point here is where it is an issue in this way, then you're in tidal lagoon territory, which is the very case the learned judge referred to, and upon which my learned friends rely, but they just don't go so far as to include paragraph 31, which is, we say, quite important. So that's the only point on paragraph 93. Paragraph 94, the judge at 94 looks at the statutory words under consideration and notes Mr. Brown, who was instructed on behalf of the appellant below, submitting, King's Counsel, submitting as a matter of language the extension of the definition to include everything incidental or ancillary to very considerably widens the scope of the application of the restrictions imposed by Section 5 of the Act on the location, must extend beyond the crematorium building itself, otherwise the extension of the statutory definition to all incidental or ancillary elements would be OTOs, refers to Guy, and then at the bottom, 5 lines up from the bottom in the middle, Mr. Brown argued it was immaterial Horizon did not propose to permit ashes to be scattered at the site. Horizon's proposals for the storage and deposit of ashes in sealed containers involved their disposal and were accordingly incidental or ancillary to the operation of the crematorium and within the scope of the definition of crematorium in Section 2 of the 1902 Act. I think the ladyship very fairly put to me whether our case had been somewhat refined earlier, and I think I'm trying to give the court the right answer on a point which seems quite important. So, yes.
You say this is the point at the heart.
But this is exactly that's the one at the heart.
And Mr. Brown was focusing on that rather than the car parks.
He was, yeah. And then the learned judge gives the example of landscaping 5 lines down in 95, right-hand margin, to take an obvious example of placing some limit. It's not anachronistic to think that even in 1902 the promoters of the crematorium might have wished to carry out planting and landscaping along the boundaries. Without doing violence to the natural meaning of the words, such planting or landscaping might properly be described as incidental or ancillary to the crematorium. Well, we respectfully say that does do violence to the natural meaning of the words, particularly when regard is had to the purpose of the legislation correctly identified. So, Judge Wright that there needs to be a limit, and the limits need to be identified on a principled basis, having due regard to the purpose of the legislation. So, if we can go over the page, if we may, to 111.
So you say the judge was wrong in 95?
Well, no, 95, the point in 95, my lord, is what he says is correct.
Right.
In A, there must be some limits.
Yes.
B, planting is obviously out. All agreed. You're planting on the edge of the boundary, obviously out. But we respectfully say that where he says, without doing violence to the natural meaning of the word, such planting or landscaping might properly be described as incidental or ancillary to the crematorium. And we respectfully say that isn't actually quite correct, because it has to be incidental to the purpose.
Yeah.
So in that limited respect, we would say it's not.
Well, he refines it later on, doesn't he? And he does talk about the purpose of burning the human remains, which is specifically what the...
absolutely, Milady, that's absolutely right. All I'm saying is it's not a helpful example of where the limit should be drawn.
You can see exactly why he says it, because at that time he was faced with an argument that it extended to the car parking and to the access road.
Indeed. And there's a compelling reason why the access roads can't be there. Is because if they have to be 50 yards away from the main road,
you wouldn't ever have any access.
Bit of cross country.
Bumpy trip. Yeah.
So it would be a bumpy trip, particularly in an area with groundwater flooding. So, that's obviously out, and the car park is obviously out as well.
We'll come to this because we're going through these paragraphs.
Yes.
And so I don't want to take you off your course, but I've read back and ahead. The information you've given us about storage or disposal of ashes above ground in the memorial garden doesn't seem to have been clearly in front of the judge in that way. He was receiving objections that had been made by Mercia about the memorial gardens on the basis that scattering was going to take place. But by then, Horizon had said, we're not going to scatter ashes. And the judgment records a number of times Horizon saying that we will store ashes. It's not said where they'll be stored, pending their removal from the site. And so I'm just parking that in everybody's mind. Because
I mean, one wants to be fair to the judge.
We might have to look more carefully at what the judge knew and what the evidence is that this is what they're going to do.
Yes, well, I may
where that leaves us.
Because I didn't appear below, I might have to take instructions over lunch just to make sure that...
And I may be wrong, because I've just done this quickly while you've been submitting.
If it helps your lordship, if you have a look at the paginated judgments, pages 91 and 92, and particularly dealing with the terms of, I think it's paragraph 40 of the judgment through to paragraph 42. So if that was a concern that your lordship had in that regard, then that may assist you as to where the matters were before the judge.
Well, I don't want to thank you. We don't want to take time now, but I'm just having clarified the position when we came back after the break. I was then looking to see what happened. But you must carry on through the judgment, and we need to perhaps go back and look at that in more detail.
I'm most quick.
Yeah.
There's a rubber part of the chair which catches one's gown.
All right.
Where it folds up, so one can sometimes get
And you assumed your junior was trying to catch your attention.
I once ripped mine in a similar situation, so I have every symptom.
Well, lady, I've got my junior gown has got a massive rip from the terror of the company's court and being called on, and I was stuck. And I thought the only thing to do is just stand up, and there was an almighty rip. I mean, I was quite junior at the time, and I've been the rip ever since. But now
There was also a vicious nail in Court 10. It always ripped your tights, but that wouldn't
I haven't got that one.
There we are. Well, we're getting too much information. We're on paragraph 96 now.
Yes, I'm just dealing with this page on 111. The learned judge identifies at paragraph 98 the long title, and then says statutory purpose is evident from the terms of section 2 itself, which defines a crematorium as a building fitted with appliances for the purpose of burning human remains. And we respectfully say it's a small point, but it is a small elision that the judge has made between the reference to the appliances fitted for the purpose of burning human remains and the statutory purpose itself, which of course he identifies as public health and we say was actually very heavily more towards public sensibilities and striking the balance to facilitate crematoria and those public sensibilities. So the word purpose is a enticing false friend in that, because it's an elision that isn't actually analytically correct. And then halfway down on the right-hand side of that paragraph, in my view, that statutory purpose sets the context for and explains why Parliament enacted the locational restrictions. So he says the separation distances imposed by Section 5 were imposed for the purpose of regulating the burning of human remains. They were intended to apply to any part of the process of burning human remains at a crematorium, irrespective of where that operative element of the process was carried out within the main crematorium building itself. And we respectfully suggest that he's confining it there only to the burning of human remains itself, and not what was ancillary or incidental to it. Right. So even on that point,
even on the words any part of the process.
Well, he says if we look at what he says throughout, he does seem to be. I mean, it's obviously right trying to be fair. I think when we read it as a whole, he does seem pretty hyper-focused on various places saying the actual burning of remains and things.
But he's not in 100. He's not in paragraph 100.
That's right. We can come to that.
I mean, there's an interesting question about whether he's too narrowly focused, and then I imagine you don't disagree with paragraph 100, but then you probably say he reverted to his narrow focus when he gets to make the decision.
It's the slalom point, my lord, yes. So he seems a bit, he's on one side, he seems to be on one side, and then he goes a bit broader in paragraph 100, and then he goes narrow again.
I mean, 100 is, do you take any issue with paragraph 100?
There is the point of public health.
Yeah.
I mean, there's misidentifying the purpose, which is implicit.
Okay, well, apart from the public health, well, he goes on, and for the protection of neighbouring residential occupiers. I mean,
that's fair. I mean,
to be fair, I mean,
if you add to the word sensibilities, protection of sensibilities of neighbouring residential occupiers.
He says that the strewing or burial of ashes on or in the open ground, so on or in, is an incidental or ancillary part of the actual process of burning human remains. I'm not sure why. Yes, that's what I'm putting to you.
Yeah. Yes, I mean, on its own, if that's all we had, we had the correct purpose in mind, which he almost is getting to there. That would lead, we respectfully say, on a proper construction of the statute and regulations, to the outcome that we seek before the court.
We haven't seen the guidance yet, but I'm assuming I think that I have looked at it, but I think that's a fair reflection of what it says.
Yes, I'll have a quick look at the guidance in a moment. But he at 101, he then reverts to his primary purpose to protect public health, which is where the sensibilities part of it appears to disappear again. And then he says he hasn't derived any real assistance from Guy's case, where Guy's case is the master roles identifying the enactment following the direction given by Mr. Justice Stephen and so forth. And then he says about Guy's case, the importance of respecting the limits of protection which the legislature sought fit to create under the Section 5 of the 1902 Act. That's really, we respectfully say, the judge agreeing with the submission that I've made to the court, which is these are limits being set by Parliament.
I mean, as I understand it, you say, look, if you put 100 side by side with 105, in relation to the memorial gardens, because that's where we're really focusing.
Yes.
My understanding is you say, look, you'd have been happy with 100, and if you'd have followed it through to 105, you'd have come to a different view.
Exactly.
But he didn't.
He didn't.
And you say that's why he went wrong.
Exactly. And it does look, I mean, that's basically a summary of the submission, but it does look as if he kept being distracted by the purpose of public health. Because that's what he goes back to.
Well, or
101.
just distracted by the fact that people were making an argument to him, by reference to access roads and car parking areas as well. If he'd have focused, as you have agreed, you have refined the case on the memorial grounds.
Yes.
Just being fair to the judge.
No, totally. And that's, I recognise that. I don't want to be unfair. I did a case as a junior against the judge when he was in Silk, in an area which I knew nothing about, compulsory purchase, or another area. An incredibly nice opponent. And it's a careful judgment, and I don't want to be unfair. I'm not unfair about it.
Yes.
So the emphasis on, when I was saying there's elements in the judgment which appears to show some very great focus, if you just take an example, 102, which is one of the gap paragraphs that Lord Justice Snowden identified, between the 100 and 105. Bottom of there, he says, right half across the right-hand side falls to be answered by determining whether on the evidence that building structure or open air area is actually used in the process of burning human remains at that cremation facility. But he says, unless that is the case on the evidence, the building structure or area is not subject to the 200-yard separation distance.
You say that doesn't give effect to the meaning of incidental or ancillary there too.
Exactly. And it also doesn't work with strewing the ashes.
What would?
Well, I have all sorts of problems with strewing the ashes, but that's not going to happen, so we don't have to worry about that at the moment.
I mean, as I understand at the moment, you're just simply saying, look, at the end of 100, he appeared to understand why, either because of public health or protection of the sensibilities of neighbouring residential occupiers, a part of open ground on which ashes would be kept, for want of a better expression. I'm not sure you bury something on the open ground, but that's, that's the point. Was incidental or ancillary to the actual process of burning human remains, which is your case.
Yeah.
And you say by the time it gets, though, to 102 and then 105, it has ceased to be.
Exactly.
And they did 108.
Yeah. I mean, that's really the short point. So that's really all I really want. That's rather shortened, more succinct version of what I was going to say. But could I just now briefly deal with?
Sorry, just on my
yes.
hobby horse.
Oh, sorry.
About paragraph 104.
Yes.
Okay, so the beginning of 104, Mercia's contention that Section 5 required the memorial gardens to be located further than 200 yards from the neighbouring property was founded upon the assertion that the gardens were not used for scattering ashes. They had made that assertion in response. Horizon told Tandridge that they weren't going to be permitted on the site and given details of the alternative arrangement would put in place for storage of ashes in sealed containers pending their removal from the site. Although Mercia continued with its assertion, the inspector used scattering ashes. Horizon's position remained as stated. Scattering ashes. So he's fixed there on memorial gardens are okay because there's no scattering.
Yes.
And he seems to be contemplating storage pending temporary removal. Then 105, second sentence, there's no evidence any part of the actual process of burning human remains in the proposed cremation facility would be carried out in the memorial gardens. And so the factual basis of Mercy's assertion fell. So I'm just not sure that he had in mind that there would be the potential for long-term placement of urns.
Yes.
That's dealt with in 106, isn't it?
Well, The last,
actual arrangements, the last sentence of 106
well, and 107.
and 107.
Yeah, because he does
Pending their subsequent
pending
removal.
is
That's the-
106, I think. And then he says he does seem to have had it in mind, because 107 halfway to,
he rejects the argument that holding the ashes in sealed containers should be seen as the disposal of ashes at the end product. And he said that process will have been completed anyway when they're sealed into the containers. I mean, like my lord, I'm at the moment it appears that the way that the matters panned out before the inspector are very different, because the objection that was taken before the inspector was that part of this is going to be used for scattering ashes, and that is prohibited by, amongst other things, by the statute, and the guidance helps you in saying that the statute prohibits that. That's then met with that objection, which was before the inspector, is then met by the developer saying, we're not going to do that at all.
yes.
The inspector, as far as I can gather, was never faced with an objection that it's objectionable to put sealed containers above the ground in the memorial garden, and that infringes the statute.
Well,
That case was never run before the inspector.
Well, I not having been involved with that, I need to just check whether that's correct, my lady. But I can see, obviously, I can see why you say that. But,
So effectively, the case that you're developing before us is a different case from that which the inspector had to face.
but it's not a different case than was developed before the judge.
Yes, and I'm certainly assisted by the references we're taking to paragraph 41 and 42, which the judge clearly was reading out emails, I think they are, which describe in turn the storage structures and pillars. And
They were the emails to which I referred the court.
Concrete base and all that, yeah.
The only reason I'm raising it, Mr. Green, in fairness to you, is because we're dealing with all of this in the context of a statutory review, where the inspector can only be lambasted for getting something wrong in narrow circumstances. You would say, well, he got the law wrong in relation to a point that wasn't run before him.
Well, that's not quite what I would say.
No.
I'd say he got.
All right, that's my gloss on
Yeah,
it. But
I think
that's what it boils down.
But I think the point is that if you've got before you, as an inspector, something that they take a good point, say, well, Memorial Garden's going to do scattering ashes, and the developer goes, we're not going to do that. We're going to do something different. I think it is before you as an inspector as to whether that difference brings it back in, just to be fair to
All right.
those who run the case below.
Okay, right, on we go.
And just to be clear, you say the last sentence of paragraph 107 is wrong. It's just factually wrong.
It is.
Because it is a proposed use of the Memorial Gardens to do exactly that which was set out in paragraph 42.
Yes. I mean,
Modest ash storage structures and pillars which can incorporate urns in the Memorial Garden.
exactly.
Yeah.
Yeah. I mean, to be fair to the learned, to be absolutely precise, my lord, the last sentence of 107 says the actual disposal of ashes, and then confines it. He says whether by scattering or burial.
Yes, but he's used the expression burial, as I pointed out,
Yes.
in paragraph 100
Exactly.
to mean burial of ashes on or in the open ground. He seems to use the expression burial to mean both.
Exactly. So we would say, construing them two together as consistent, the last sentence of 107 is wrong, as your lordship put to me. But for that reason. Yeah. My lords, my lady, could I just deal with a few points arising on my learned friend's skeleton arguments in relation to this issue?
Yes.
So if we first go to tab 3, which is my learned friend Mr. Darby's skeleton argument on behalf of the Secretary of State. there's just a very tiny point of correction on page 40 in the bundle, paragraph 19. It's a point that's in my favour, but it's just a typographical one. In the quote from Guy, and I know the court will use the authorities bundle rather than this, but I just want to be fair, not to leave something that's in my favour wrongly. Paragraph 28. There's just accidentally the line, I accept the passing of the Act was to prevent the public seeing the cremation. That's just a mistake. The report does not say that.
Gosh.
I think it's just copying and pasting the two lines together.
Oh, I see. Yes, because it's got the end of the previous line and the beginning of the next line.
Yeah, exactly.
Yeah.
It's just a typographical thing, but it's in my favour, but it's wrong. So I just wanted to make sure.
Thank you.
Then, just going forward, if we may, to page 46, paragraph 43. The proposition there is the judge was correct to find that the words incidental or ancillary thereto in section 2 are properly to be read as linked to the purpose of burning human remains rather than the building itself. That's the point my lord put to me earlier, and that's correct. But what's then reasoned from there, it would clearly exclude the memorial garden, which has no link to that purpose at all. We say that's plainly wrong for scattering or interment. And we say also for storage for all the reasons I've already identified. Going a little further, on page 48, at paragraph 52, the respondent 52 and 53 places considerable weight on the 1978 guidance, which could not be clearer, etc. Can I just take the court to that guidance, because we haven't looked at it yet, and that is in the authorities bundle at the very back in tab 17.
Yes.
And there is a section on page 294 with a capital letters heading the building.
Yeah.
And it refers to section 5 and so forth, and paragraph 18 says by section 2 it means any building, etc. And then third line down it says the department is advised that the crematorium buildings, chapels and parts of the grounds used for the disposal of ashes come within this definition, but not ornamental gardens, carriageways or houses for staff. So that's what the guidance said. The court will note just on page 296 in the explanatory note that section 188 of the Local Government Planning and Land Act 1980 and the relevant part of Schedule 34 rescinded the requirement in section 1 that the sites and plans of proposed crematorium must be approved by the Secretary of State. We feel that we must stress the above memorandum was only issued for guidance and certain aspects may well be out of date. However, prospective cremation authorities may find it informative, which is why it has been decided to continue to publish it in this directory. So just to give the status of that guidance clarity. So just going from the guidance back to the long friend skeleton argument.
But again, I don't think you don't disagree with that guidance,
No,
provided that the word disposal of grounds used for the disposal of assets covers putting the assets. Sorry,
Ashes.
ashes. I will go.
it was actually 2 hearings, my lord, about assets. So
It was
maybe your
two.
lordship can be forgiven. Yes.
It was. Provided
Disposal
you
of
say
assets.
that the disposal includes placing in structures above ground.
It does.
Yeah.
I mean, in the end, that's what the appeal comes down to.
It
Yeah.
is.
Yeah,
No.
it's a straightforward point. And that's what it comes down to. It just looking, if we may, just on that point, 52 and 53 on page 48. The guidance cannot be clearer, expressly noting parts of the grounds used for disposal ashes come within this, but not ornamental gardens, by which they mean purely ornamental, etc. 53 is interesting because it says the structure of the 78 guidance is itself instructive, with the heading the building followed by a series of subheadings, various sections of the building, including the porte cochere, the doorways and gangways, entrance hall, waiting room, vestry, chapel, crematory, ancillary space, paragraph 49, chapel of rest, service yard, and superintendent's house and office. It is these various sections that are most often to be read as reflecting the incidental or ancillary features likely to fall within section 2 definition. Now, we disagree about staff accommodation, which is expressly excluded by the guidance, but we completely agree about the service yard falling within section 2. So we agree with the Secretary of State's submission about that. If we look at the back page 296 has the ancillary space. So, for example, a small staff room, a workroom, lavatory, WC accommodation, a fan room, suitable accommodation for the pulverising machinery and for the storage of ashes, and space for a central heating plant. And it gives suggestions about these rooms being sited a little bit away from the chapel for reasons of noise, obviously. And then the chapel of rest is at 50. And then service yard will be required outside the crematory, suitably screened from view. The entrance to it and through it to the crematory should be large enough to allow movement of bulky equipment. The yard can conveniently incorporate the gardeners and maintenance stores. So we respectfully say, actually on the Act, the service yard should be in, which is the only other one I said that should be in.
And on that reading, it doesn't matter that the yard is just now a space with no thing in it. It's a necessary requirement because you've got to have service vehicles.
Yes.
Big enough space for service vehicles to come into
the maintenance of the machinery.
the back of the operation.
Exactly. And my lord, in fact, the drawing delineates where they've put the gas
Yes.
now, but it's just part of, in real life, it's part of one yard. It's not separated off.
But the gas canisters, I well understand, are incidental.
Ancillary.
Get it right.
Sure.
Incidental or ancillary.
Incidental or ancillary to the burning.
Yes.
I think, and for
Or
pretty
for the
obvious
purpose of burning.
for the purpose of burning, pretty obvious reasons. But just somewhere for delivery vehicles, delivering things which are completely unrelated to burning, but
Well,
just to the general operation, like the paper clips to the
No,
offices.
well, it's not the delivery of paper clips that makes it incidental or ancillary, nor does the fact that someone delivering them might drive into the service yard. The point is that the service yard is essential to the operation of the crematorium for the servicing of the equipment. So,
Because you've got to have some vehicular access for vehicles that are concerned with the purpose of the burning.
as opposed to the car parking for those that
I
aren't.
don't know what those would be, but
What if the service vehicles went into part of the car park? Would you then be saying that part of the car park was ancillary?
Well,
There wasn't a separate space for.
It's for servicing the building.
It's for servicing the building and the equipment installed in the building for the purpose of burning
I suppose.
human
Yeah,
remains.
I suppose.
If the machine breaks down. then-
Exactly.
Yeah.
Sorry.
Yeah.
No, that's absolutely right. It talks about the movement of bulky equipment, by which I suspect they mean
Haulage.
Some parts of the
some parts
cremator,
of the actual cremating or
Yeah.
pulverising machine.
and one can see why, from a sensibility point of view, that really is all part of that operation.
And it's to be shielded from
Yeah.
view.
Yeah, and it normally is.
And the service yard is outside the permitted.
Yeah. There's a sliver.
line.
There's a sliver that's
Yes.
within, but most of it is outside.
Yeah.
Well, in that sliver, they've now located the gas line,
Exactly. No, completely.
and I think also the photo cell.
I think they put the photo.
They sell somewhere
On
else.
the roof, I
On
think.
the roof. Yeah.
I think they've moved onto the roof from memory.
Yeah,
Not sure
yeah.
if I'm right about that. But I mean, the short point is they've moved.
But
the
your
most
your
obvious-
argument is moving the gas canisters doesn't take away the point.
Doesn't take away the point because they're in the service yard. Just happens a bit of the service yard is within and a bit is without.
Yeah.
So it's really a short point there, and one that on the face of paragraph 53, my learned friend seems to agree with.
Yes.
55, paragraph 49, the appellant's approach also runs contrary to what any reasonable person would associate with the act of burning human remains of the features of the crematorium by way of a degree of functional connection. In this regard, the judge's conclusion was that such facilities as a chapel and a ground for disposal of ashes are functionally connected to the process of burning human remains, whereas ornamental gardens are not. But we agree that the chapel, and indeed the chapel of rest, and the ground for disposal of ashes are functionally connected. And they're no less functionally connected because you're storing them above ground by 2 centimetres than they would be if you're having to store them 2 centimetres below ground. So that's the functional connection point that I make as an overarching point in approaching the words incidental or ancillary to. And then if we can go over the page to page 50, this is the continuation of paragraph 57. Two lines down from the top. If, however, the instructions are not for disposal, say, for example, they're for storage in the manner envisaged by the appeal proposal, which they seek to distinguish, then the requirement under section 31A simply does not bite. So that was what I reverted to when I was making my submissions on the regulations, which is quite an astonishing proposition, if true. So that if you say I'd like them interred, regulation 31A obliges the crematorium authority to inter them. If you say I'd like them scattered, they're obliged to scatter them. But if you say I'd like them in the cairn, just above where you would have interred them, they can do what they like. Now that cannot be right, we say. And obviously the court is dealing with an option that was not at the forefront of the drafter's mind when the drafting was done. But it's functionally the same. It's a question of what happens with the ashes at the end of the process. We simply say it cannot be right that regulation 31A simply does not bite as the Secretary of State submits. So, my lords, my lady,
and even just thinking, it does happen that after ashes are interred, interred here, and then the spouse lives another 10 years but dies somewhere else, and the family want to have Uncle Arthur with Auntie Betty or whatever it is. The interred ashes are disinterred and moved.
Yes, they can be.
They can be. So the distinction between having the urn above ground and below, it becomes less distinct.
If distinct at all.
Not distinct at all.
exactly.
Once it's scattered, they're scattered.
That's it.
Yeah.
So, my Lords, my Lady, unless I can help you further on that point, I've spent most of my time on it for
Yes.
hopefully obvious reasons. I'll be very brief on
Now the
flooding.
flood. Yeah.
And I'll try and finish by 1 o'clock,
Good.
keeping a beady eye on the time. The flooding point is one which the local residents feel quite strongly about, and one on which they adduced evidence, and one on which the structure of the sequential flood risk assessment is quite sensitive. So what you get is a flood zone. My lady knows all this, so I'm sort of a bit embarrassed making this decision.
I don't.
Well, if I look that way, it's no disrespect, my lady. But as I understand it, I'm sure I'll be corrected if my short summary of it is materially wrong. But the short point is that you get a flood zone rating for fluvial and sea marine flooding. So flood zone 1, 2, 3. And then you have to actually work out if there's surface groundwater flooding separately and if there is taken into account. So the only point is the fact that you're in zone 1 is not the end of the analysis. I'm getting a
And
nod.
the judge accepted that.
And he accepted it.
Yes.
Quite rightly, I'm just to narrow the...
Yeah.
Zone 1's the lowest zone, but
Exactly.
it's not the end of the story.
It's not the end of the story. And here, the story was that
But the story, if there comes a time when you have to undertake this sequential
Exactly.
test, which involves looking at other sites and
Exactly.
other options.
Yes.
And so what I'm not clear about, and you're going to tell me, is what's the trigger
Yes.
that takes a case like this, which is in zone 1 but has got additional potential for groundwater flooding, into the sequential test, or not, as the
Exactly.
the
And
judge and the
I
other
think
parties hold.
trying to... I'll hear what the learned friends say about substation to amplify their submissions and hopefully be able to help in reply. But the short point is, if you're not on the green belt and there's a possible groundwater issue, whatever it is, the applicant on the authority of substations does not need to prove, quite understandably, that there are no other sites with a lower risk. So prove a negative. I mean, that seems to me not very surprising result.
Because if the opposite was true, every application would have to go off and look at alternative sites
Exactly.
outside the green
Yeah.
belt.
And our point on this is a relatively short one, which is that where in fact what you're dealing with is a planning application on the green belt, where an assessment of alternative sites has in fact been made, and although it didn't capture Farley, where there's Farley's the one where they turned down planning in a much bigger site with room for expansion, which Horizon themselves said was an important factor here, because this one had been granted and there's no problem of water at Farley. But we've got the opposite outcome to what the policy predicts, but that's not, it's just a background feature. But the short point is that Farley was put before the inspector as an alternative, and indeed alternative sites were identified. There were 9 plus 2 in total, 11. And the short point we say is, on the correct approach, what should happen is, where the assessment of other sites has been undertaken in any event, because it's greenbelt, and you've had to do that assessment and put it before the inspector is then seized with that information, and where there is a clear groundwater flooding issue on this site, that triggers the sequential assessment.
So you say there's a clear... you'd have to be a bit more specific about that. I didn't think there was a, quote, clear groundwater flooding
Well, no, sorry.
issue.
So I should have said a clear risk of groundwater flooding, because that's the correct threshold. I misspoke.
Yeah.
What you have to show is a clear risk of groundwater flooding.
I mean, I think it's...
Because
what's the expression? Potential.
Exactly. And indeed, the policy itself is focused on directing development to the areas of lowest risk.
Good try. But there's a few problems with that
Very
proposition. The most fundamental problem with it being that it's up to the planning inspector what he does with the information. So it's a question of planning judgment for the planning inspector as to what information before him is regarded as material or immaterial, unless there is policy guidance, statutory mandation that you must take it into account. So I'm interested in knowing what legal principle you're fastening on to say that it triggers the sequential assessment.
Well, only the principle of rationality.
Okay.
Because that is a
so you say it's irrational not to take into account.
Yeah,
Right.
it is. If you're deciding, shall I do a sequential flood risk assessment or not, and you know that there is a particular risk attendant upon this site and this development, it's irrational not to follow that through to a reasoned conclusion.
Well, this planning inspector said, I take into account the fact that there is a potential risk of flooding, but that risk can be mitigated by the conditions that I'm going to place on the grant of planning permission. And he then produces condition 6, which has very, very detailed conditions in relation to drainage, etc., etc. So how can it be irrational to decide to place conditions rather than start looking at other sites?
Well, because the express purpose and aim of the policy is to direct development to the areas of lowest risk, not to retain development in areas of higher risk and put lots of conditions on them. So, in my respectful submission, the clear primary driver is the directing, and when you've got two close sites, very close, on which an assessment has already been done, leaving out of account the other 11, you've got those two sites, and you've got the option of doing what the primary objective is. We respectfully say it's wrong not to do that.
Well, the other site's not got planning permission, and there's also, I think, a fact finding somewhere that says there wasn't an alternative suitable site.
Well,
or am I wrong about that?
I'm not sure about that.
I can't remember whether
check.
it was made by the judge or whether it was by the inspector, but I certainly remember reading a statement somewhere that said there was no alternative suitable site.
Let me check in
I'll give
relation
you a chance to check that over lunch.
Yes, I'll
it's
check that over
unfair to
lunch.
bounce you on that.
No, that's fine.
But that was one of the things that stuck in my mind when I was looking at this.
Yes, I mean,
was
to-
whether that was a potential obstacle as well.
to the extent that that was a finding, it was obviously wrong, we say.
But it wasn't challenged.
Well, it was the outcome.
Anyway, you have a look at it. It's unfair of me to bounce.
No,
you on
it's
that.
perfectly fair. I perhaps should know the answer already, but
No.
I'll try and check that over lunch, lady, and assist on that. But the short point is that the framework and practice guidance makes it absolutely clear that the judge, at paragraph 22 of the judgment, recites paragraph 162 of the framework. It's at page 83 in the bundle. Sorry, let me just check. Yeah. So, just to be absolutely clear, the judge identifies the sequential approach and the role of the sequential test as being set out in 160 to 162. And then he cites 162. The aim of the sequential test is to steer new development to areas with the lowest risk of flooding from any source. Development should not be allocated or permitted if there are reasonably available sites appropriate for the proposed development in areas with a lower risk of flooding. The strategic flood risk assessment will provide the basis for applying this test. The sequential approach should be used in areas known to be at risk now or in the future. So that's the risk point, I think my lady and my Lord Justice Snowden put to me. And So if we look on 84, the practice guidance at paragraph 25 recited by the judge at the foot of paragraph 25. Within each flood zone, surface water and other sources of flooding also need to be taken into account in applying the sequential approach to the location of development. So your lady's quite right. He does acknowledge it there. But the assessment made by Horizon suggested there was no problem at all. We say, first of all, it's clear that it has to be, surface water has to be taken into account, which I think is uncontroversial. And secondly, it is important to give effect to the primary aim of the guidance and the framework. And the primary aim is to direct it as between sites to those with the lowest risk. And here you had examples of other sites with lower risk without that problem. And in particular, Farley, to which Learned Friend says, well, it's been refused planning permission. But we can see from the update to the guidance in 2022 that it's a reasonable prospect. Doesn't mean you're barred by the fact that it's been initially refused planning permission. We say a reasonable prospect includes the possibility of a successful appeal, just as there was on this site. And in fact, we know that the Farley site lost because this site was granted. That's the very reason, and no other. That rather, we respectfully, that rather vindicates our point on the flood risk. It was a perfectly...
I found the passage that I was considering, Mr. Green, so you can have a chance to look at it.
Yes.
It's paragraph 33 of the inspector's decision, which of course one doesn't read like a statute.
That's right at the back, isn't it?
It's on
Yes,
pages 284 and 285, and it's 285. It's at the bottom of 284. Were I to conclude the sequential test was necessary due to a medium degree of flood risk, you've got to, the PPG says you've got to look at a practical approach, pragmatic approach to the availability of alternatives. He then refers specifically to Farley.
Yes.
He says it's been refused planning permission and appeal decisions pending currently. I consider there to be no reasonably available sites at a lower risk of flooding to this scheme. Now that's paradigm example, is it not, of an exercise of planning judgment. And then he says, in any case, I'm satisfied with the conclusions of the FRA. There's no requirement for a sequential test. So he's hypothetically applying a sequential test, finding as a matter of fact that he's not satisfied that there is an alternative that's reasonably available, and then he's imposing the conditions to mitigate. Now, at the moment, I can't begin to see how that can be described as irrational.
Well, the only question, lady, is whether he properly understood the guidance as to what reasonable prospect meant.
Yes.
Because I think that is quite important.
Yes.
Do you,
Yeah. Yes. So we've got a copy. The guidance was updated in 2022. It's referred to...
Sorry, that's after the date of the
Yeah, I know.
decision.
Understood.
Well, then we can't take it into account.
No, I quite understand. I'm just suggesting that I'm not suggesting the inspector should have taken account of guidance he didn't have.
No.
Of course not. What I'm suggesting is the guidance, as it now is, just reflects what the proper approach...
If we can't take it into account, then we shouldn't be
Well-
hearing about it, should we?
Well,
Speaking for myself, I don't mind if you have the guidance as it was at the time. And
indeed.
if he didn't properly take that into account, that's one
No,
thing.
all I'm simply suggesting is the proper construction of the guidance at the time meant that the requirement of a reasonably available site meant one for which there was a reasonable prospect of that development, just as the guidance now explicitly
So
says.
it turns on the inspector's conclusion.
Yes.
The passage my lady's taken us to.
Yes.
I consider there's no reasonably available site.
Yes. And if I'm wrong on the point about reasonably available, including one where there's a pending appeal, on apparently by the same criteria looking like quite an attractive site, if I'm wrong about that, as a matter of principle, then I'm wrong on the whole point.
Yeah.
which I have to accept.
As I understand it, it's the word currently. Currently is, there is currently not a reasonably available site because it's been refused planning permission.
Yes.
You say, but that doesn't take into account the fact that an appeal is pending.
Which is noted.
And and the sole reason for refusal is that the site we're looking at.
Well, we don't know.
We don't know.
We don't
know why they refused to.
Well, we have got that. I'll just dig out
You
quick
said
reference.
You've said it a few times.
I'll show you the references for that after lunch. It'll take me 2 minutes. I don't know.
Well, we're getting a bit dot and carry now. So that's clearly a convenient moment. You may have finished your submissions, but you may not obviously have.
I'll just show you the references for that
time.
point.
Can I ask for one thing? And
Yes.
it may be that it's in the bundle. If it's not, Mr. Goatley may be well placed. At paragraph 42 of the judgment, there's a quotation from an email of the 24th of July about the storage structures in the Memorial Garden. And it says, I attach the illustrative layout plan for the garden that's been prepared by the landscape architect. And if that's available, that might be
Might be one of the ones we've seen.
helpful for us to see. But
Maybe
I
I'll
haven't
have
seen anything in the bundle that looks like that.
No.
The email you took us to didn't have an attachment. But if we've got it, then that would be a welcome addition.
My Lord, I'll take instructions as to whether or not it is in the bundle or whether or not it can be otherwise summed up.
Very good.
My Lord, whilst I'm on my feet, one of the matters that rose was the regulations, the 2008 regulations.
Yes.
We've had those copied during the earlier adjournment. Would that be something you'd like to have now or after lunch?
After lunch. Yes.
Okay.
Yeah.
Thank you very much.
Thank you.
There's one point on those I'll make. At the
Very
same
good.
time as the references.
Well, we'll
2 to 3 minutes.
leave that hanging. Can we be back at 2 o'clock, please? Thank you.
Thank you.
All eyes, A1.